Why submissions by Ñnamdi Kanu's lawyer will fall like pack of cards. Welcome to this news. Please listen to the end. Of all the submissions put up by lawyers to the leader of the indigenous people of Biafra, HIPOP, Mazi Ñnamdi Kanu, the only one that will be irrefutably in their favor is submission number 18, considering that there is no such law as Cap 677, as quoted in Count 1 and Count 2 on the charge sheet. The remaining submissions by Ñnamdi Kanu's lawyer will fall like a pack of cards. However, if the Department of State Services, DSS, quickly changed the law decided from Cap 677 to Cap 638, and the judge allows that change to be made, then even the submission number 18 by Ñnamdi Kanu's lawyer will be irrelevant. Here are the submissions of Ñnamdi Kanu's lawyer. According to Kanu, in a preliminary objection filed by his lawyers, led by Ifeanyi Ejiofor, the charge as constituted does not disclose a prima facie case against him. 1. An order striking out or quashing and or dismissing the 7-count amended charge, specifically counts 1 to 7, preferred against the defendant or applicant in the amended charge number FAC/ABJ/CR/383/2015, for the reason that the counts as constituted are incompetent and thus deprives the Honorable Court of jurisdiction to entertain the same. 2. An order of the Honorable Court discharging and acquitting the defendant or applicant of all the counts in the 7-count amended charge preferred against the defendant or applicant upon the same being struck out or quashed and dismissed. Further take notice that the objection is predicted on the following grounds, namely: I. That the 7 counts preferred against the defendant or applicant in the amended charge is incompetent, and consequently the Honorable Court lacks the requisite jurisdiction to entertain the same. I. That allegations in the 7-count amended charge, particularly counts 1 to 7, is that the defendant, particularly counts 1, 2, 4, 5, 6, and 7, is that the defendant or applicant made a broadcast in London, United Kingdom, but that same was monitored in Enugu and in other parts of Nigeria. That no allegation was made in any of the counts of the amended charge that the alleged sundry acts of the defendant or applicant were physically carried out by him within the geographical space or territory boundaries of Nigeria. IV. That the only element requisite to constitute and found liability for incitement is the actual words allegedly uttered by the defendant or applicant. V. That the alleged acts ascribed to the defendant or applicant as constituting offences were not made up of several elements. See Section 12 of the Criminal Code Cap 38, LFN 2004. That the element of alleged inciting statements did not occur anywhere within the territorial boundaries of Nigeria. Further, that the only element requisite to constitute liability for incitement allegedly occurred wholly and entirely in London, United Kingdom, and not anywhere within Nigeria. VI. That jurisdiction is intrinsic to adjudication. It is conferred on the court. Argued, it is not intrinsic. See Sylvester Okonkwo, Honorable Ebele Obi and ORS 2019. LPEL 48183 CA. All Progressives Congress, Honorable Godwin Etim George and ORS 2019. LPELR 47003 CA. VII, that the principal legislation that governs the trial of offences in Nigeria, namely the Criminal Code Act, Cap C38, LFN 2004, in Section 12 thereof, clearly delineates the jurisdiction of a court adjudicating over a crime, that the provisions of Section 93 to 96 of the Administration of Criminal Justice Act 2015 does not purport to displace any part of Section 12 of the Criminal Code Act, neither does the Terrorism Prevention Amendment Act of 2013. VIII, that as the old elements necessary to constitute incitement in the alleged several broadcasts of the defendant or applicant occurred in London, United Kingdom, and not in Nigeria, the court in Nigeria has no jurisdiction to try the defendant or applicant on any charge founded on any such alleged incitement, even if the defendant or applicant enters the geographical boundaries of Nigeria. X, that although the Terrorism Prevention Amendment Act 2013 purports to invest the Act with extraterritorial jurisdiction, it in no way clothes the Honourable Court with the jurisdiction to try the defendant for the said offences allegedly committed in London. X, that the alleged act for which the defendant was charged do not constitute terrorism offences in London, United Kingdom, where they were allegedly committed. XI, that Section 1A2 of the Terrorism Prevention Amendment Act 2013 imposes an obligation on the Attorney General of the Federation to maintain international cooperation for compliance with international treaties on terrorism. XII, that the international cooperation and compliance envisaged in the said Section 1A2 of the Act presupposes, among other things, that due process of law must be followed at all times, which also include that the defendant in the instant charge must be rendered lawfully from any territory outside Nigeria. Thank you for tuning to today's news. Do enjoy the rest of your day.